Ladies and gentlemen, in your deliberations, we've discussed this previously. This is the first phase. We don't know if there will be a second phase. In this deliberations, you must not consider the sentence as punishment. Your duty is confined to the determination of guilty or not guilty. In the event that you find the defendant guilty, we will then move to the second phase. Duty to determine punishment on some of the counts will rest on the court. We've already explained how this works to you. We're not to consider punishment in the first phase of this trial because we don't know yet. We'll get there. So just keep that in mind. It should not be a part of your discussions. You must not be influenced by any consideration of sympathy or prejudice. Your duty is to carefully weigh the evidence, decide all the disputed questions of fact, to apply the instructions of the court to your finding, and to reach your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence and make your finding with intelligence and impartiality without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will each feel that their case was fairly tried. Now, if during the course of the trial the court has done anything that you consider an indication of my view of the matter, you are instructed to disregard it. Your initial conduct upon entering the jury room is a matter of some importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even though you become convinced it was wrong. You're to consult with one another and consider each other's views and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after considering the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced it is wrong. However, you should not surrender honest conviction in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. Now, the court is going to, after we break here, we're going to go over the verdict forms and then we're going to break. You will then be officially, once you're escorted back to the jury room, you are going to be officially sequestered at that point. The court will place in your possession all the exhibits admitted during the trial, the verdict forms. You already have the jury instructions. I'm going to make sure that you've made those corrections that I already indicated, and then the court will give you one final corrected version that you can have, just in case you have a question. You can check the final corrected version based on what I instructed you here today. One of your first tasks when you go to the jury room for deliberations is to elect a foreman. The foreman can be a full man or a full woman, right? The foreman has certain responsibilities. The foreman will see that your discussions are orderly, that each juror has the opportunity to express his or her views. The foreman keeps track of the exhibits, and the foreman will have the blank verdict forms in his or her possession. Otherwise, the foreman's responsibility or authority is the same as that of any other juror. The foreman will read the verdicts in open court. Until your verdict is announced in open court, you are not to discuss with anyone else the status of your deliberations or the nature of your verdict. You've already sworn an oath to this. All of those that are going to be dealing with you during the course of the day, and if you were to end up going to the hotel, all of them know that they are not to discuss this case with you, and that you are not to discuss this case with them, and so they will not be asking you any questions, and they will, of course, know that you can't speak about that with them. So after you've retired and selected a foreman, and then whenever all 12 of you have agreed upon a verdict, it must be unanimous. You're to sign your verdict forms in ink and advise the bailiff by ringing the bell. I'm going to hand out the verdict forms here to you now. I want to check the correction we were making. One for the lawyers, too. These are not the original verdict forms. There will be one original set of verdict forms. This is the only set that will be filled out. These are just for you to follow along right now as I'm going over them with you, okay? The other thing I'm going to ask you to do is to ensure the secrecy and confidentiality of the proceeding. As you are going along, if you do end up reaching a verdict on certain counts along the way, I'm going to ask you not to write on these forms that I'm giving you now. There's only one verdict form that will be presented to the court. The foreman will hold on to those, and that is the only one that should ever be filled out, just in case you were to reach verdicts on some counts and then go back to the hotel. I wouldn't want anyone to be able to see those, you know, even if it were a security person or something. I just am instructing you not to fill out those forms. They are simply for you to follow along as I go through them right now, okay, because there's a number of them. All right, there's only one verdict form that should be filled out, and that would be in the possession of the foreman. Okay, so, starting with count one, you're going to notice that every verdict form has a caption. It's the case caption. This is one of those legal things we have to do. And they are all the same at the top with the same case number, party, the name of the judge. As to each count, though, the court does specify what the count is and who the alleged victim is as to that count. That's just to help you keep track of that, okay? So count one is aggravated murder, and it lists Justin Winebrenner there. Then there's a line here, and you'll see that on almost every verdict form they're going to be identical. There's just a line with a blank, and it says, we the jury, being duly examined and sworn, do find the defendant, Kenan Ivery. There's an asterisk, and there's a line, and then it says, of the offense of aggravated murder. And then it tells you to make a finding. Either insert in ink the word guilty or the word not guilty, okay? And then it indicates that you write the date, and it has to be signed by all 12 jurors. I'll tell you now, it doesn't have to be signed by your juror number, okay? You don't have to fill it out according to those numbers. There just have to be 12 signatures, one of each juror, okay? That's count one. Then there's the specifications attached to this count. And so what we will do is add to this count, just so you understand, even though they are all listed, count one and the specifications attached to it will be stapled together. As you read the specifications, you'll understand based on your finding whether you actually need to fill this out or not. Because it could be if you haven't found him guilty of something, if you found him not guilty, it will, you'll indicate by the instructions that you wouldn't need to fill that out. So pay attention to that. But specification one to count one asks you to make a finding. Having found the defendant guilty, so that's the clue. If you find him guilty, you move on. If you found him not guilty, you do not move on, okay? Having found the defendant guilty, we, the jury, further find that this offense of aggravated murder, and then there's an asterisk and a line, part of a course of conduct involving the purposeful killing of or attempt to kill two or more persons by the defendant. You're to make a finding, either the word was part of a course of conduct or was not part of a course of conduct. So that would be the finding that we would make, and once again, it has to be signed by all 12 jurors. Specification 2 to count 1, and when it makes reference saying having found the defendant guilty, it's always referring to the original charge, okay? So having found the defendant guilty, you would only fill this out if you had made that finding. We, the jury, further find that the defendant asterisk either did or did not discharge a firearm at a peace officer while committing aggravated murder. And then specification 3 to count 1, once again, only if you found the defendant guilty. We, the jury, further find that the defendant, while committing aggravated murder, either did or did not have a firearm on or about his possession or under his control, and either displayed or indicated that he possessed the firearm or used it to facilitate this offense. So that's count 1. So we would staple those all together. And then count 2 is murder, Justin Winebrenner. And basically, as you can see, it follows the same formula. You make your finding, not guilty, guilty, whatever it would be. Fill it out the date, fill out the 12 signatures. There's 2 specifications to that count. Only if you found the defendant guilty would you fill it out. Either he did not or he did discharge a firearm at a peace officer. That's the first specification. The second specification is having a firearm on or about one's person or under his control. And then the did or did not finding. Count 3, murder. Once again, Mr. Winebrenner's name is listed there. You indicate your finding, guilty or not guilty. Sign it according to your findings. Specification 1 is the issue about whether he did or did not discharge a firearm at a peace officer. Specification 2 is the gun honor about the person. As I understood, displayed it, so you would make your finding, did or did not. Count 4 also related to Mr. Winebrenner, and that's felonious assault. Once again, you make your finding, not guilty, guilty, whatever it is, 12 signatures with the date. There is an additional finding on this charge, and so that's how it's listed, as an additional finding. We, the jury, having found the defendant guilty of felonious assault, so that's the clue, that that's the circumstance under which you would fill that out. You either do or do not further find that the victim is a peace officer, a existence of which raises the degree of the offense from a felony of the second degree to a felony of the first degree. So you're making an additional finding there if you found him guilty of the underlying offense. And then there's another specification. This is regarding discharging a firearm at a peace officer, did or did not. This is the having a gun on or about one's person, did not or did. You make your finding there. Count 5, attempted murder of David Wilcady. And Mr. Wilcady's name is listed there, okay? So it corresponds with the instructions I gave you in writing. And then you make your finding on the attempted murder. Guilty or not guilty, must be signed by all 12, must be unanimous. There's a specification on this count regarding having a firearm on or about one's person. Did or did not is the finding only if you have found the defendant guilty of the attempted murder. Count 6 is the attempted murder of David Eisel. The form is essentially identical to the attempted murder charge of Mr. Wilcady with the exception of a different name of an alleged victim. Okay? So you make your finding, guilty, not guilty, sign the 12 signatures. Same specification applies, having a firearm on or about one's person, did not or did, whatever your finding is, has to be signed by all 12 people. Count 7 is felonious assault of David Wilcady. Make your finding, sign it, and then if you have found the defendant guilty, you would go on and fill out the specification. Did or did not have a firearm on or about one's person. Charge related to count 8 is Ms. Jennifer Imhoff, and it's basically an identical verdict form to the felonious assault of Mr. Wilcady, with the exception of Ms. Imhoff's name is there. Okay, make your finding. There's a specification. It's the identical on or about one's person with a firearm specification. Make your finding. Did not or did have that firearm. All right, count 9, felonious assault. This relates to Mr. Capes. Once again, it is similar to the Mr. Wilcady and Ms. Imhoff's felonious assault charges. Make your finding, must be signed by all 12. Same type of specification. Make your finding, did not or did have a firearm. Count 10 is the felonious assault charge of Thomas Russell. This is slightly different because the state is alleging that Mr. Russell is a peace officer, so you will be asked that an additional finding that Thomas Russell, that you do or do not further find that he is a peace officer. Specification count 1 to that count is the peace officer specification. If you have found the defendant guilty of count 10, then you would make a further finding either the defendant did or did not discharge a firearm at a peace officer. That relates to Mr. Russell. Specification 2 to count 10 is the firearm on or about one's person. Only if you have found the defendant guilty would you make a finding one way or the other on that. Count 11 is a felonious assault related to David Eisel. So it would be very similar to the David Wilcady, Jennifer Imhoff, and Michael Capes charges. One line here and one specification. You make your findings according to that. So if you find him not guilty, you don't fill out the specification. If you find him guilty, you make the further finding one way or the other, whether he did or did not have a firearm on or about this person. Self-defense charges, the defense, the self-defense, it's been alleged relates to these first 11 counts, and that's stated in your instructions, okay? Count 12 is having a weapon under a disability, and so you make your finding, not guilty or guilty, based upon your decision, asked to be signed. Count 13, carries concealed weapons, same thing, make your finding, guilty or not guilty, signed by all 12. And this all has to be done in ink, just so you know. Everything has to be done in ink. Count 14, illegal possession of a firearm in a liquor permit premises, guilty or not guilty, dated and signed by all 12. And then the final charge is count 15, tampering with evidence, guilty or not guilty according to your finding. So the last few counts don't have any specifications attached to them. We will staple these accordingly so you understand which specifications go with each charge. Everybody, I know that was fast. Everybody generally understand what I went through there? Okay. What the court is trying to do is I'm trying to avoid you having to ask questions. I know that that may happen. In fact, it does happen in most cases. But juries often believe the judge is going to be a wealth of information and give you incredible answers to your questions during deliberations, and the truth is usually there's not a lot the judge can tell you that I haven't already told you so. I'm giving you the instructions. First request is if you do have a question, look at the instructions first. I've tried to highlight in the instructions in bold the different subjects that we're discussing, so that may help you, you know, if you had a question about the presumption of innocence or reasonable doubt, you could look and find those words, and hopefully that would help you. So trying to avoid you having to ask too many questions. As you already know, Ms. Spears has been taking everything down, but I already told you we're not going to have, you know, just transcripts of testimony available for you as many juries would like to see happen. That's not the case, and so that would be very difficult for the court to be able to provide that to you. All right? Now let's go through the original instructions I gave you and just make sure you've made those corrections rather than having to kill another couple trees and give you the other instructions. These are minor instructions, corrections with one exception. There's just a couple. I want to make sure you don't miss. On page 24, everybody got that? Count 6, attempted murder. It's actually, it should be listed as the 6th count, and then there's a typo, it says 5th count. Probably not going to be something that you're going to worry about, but... All right, then there's specification 1 to count 6. Underneath that, remember I told you to cross that out. There is no specification. Well, it's the incorrect specification. It's peace officer specification related to Mr. Eisel. No one is alleging Mr. Eisel was a peace officer. Okay? So cross that out. So modify the specification 2 to count 6. It should be specification 1 to count 6, which is the allegation about having a firearm on or about one's person. I think you probably all got that the first time around, but I'm making sure you all have it now. Okay? And then at the bottom of page 25, there is one element that was left out in the typing on each felonious assault, so that is critical, but that is an element that the state must prove. And so that's the main reason I'm going to retype the corrected instructions and make sure you have that. I'll call it the corrected copy, but I read it to you, and that is you have to add the additional element of by means of a deadly weapon at the end of that paragraph at the bottom of page 25. And then at the top of page 26, the definitions previously given to you were actually given to you related to count 4, which was the felonious assault count, not count 5, so I don't want you to be confused. And then under count 8, the typo says it's count 11. It's not count 11, it's count 8. Everybody see that? This is one of the reasons we don't give the juries the instructions ahead of time, because of these problems, but I didn't want to make you wait another 45 minutes on some of these things. We need to add the additional element at the end of that, count 8, top of page 27, add the phrase by means of a deadly weapon. Everybody get that? And then it's the definitions given to you in count 4, not in count 5, that relate to felonious assault. And then once again on count 9, it's that additional element by means of a deadly weapon, definitions given to you in count 4. Once again in count 10, there's those two different things. Thomas Russell, a peace officer, comma, by means of a deadly weapon. The definition is given to you in count 4. And then again on count 11, the other felonious assault charge, same thing, add those words, by means of a deadly weapon. The definitions were in count 4. That's it as far as the corrections to the instructions. So I'll give you one corrected copy. If you've all made those, then I think you'll be fine. Okay, counsel at sidebar?
Just briefly.
Okay. All right. So we are now going to take you back, and we're going to have Jason take you back. We now have to separate our 12 and our alternates, at least during the portion where you select the foreman. Then when you decide to break for lunch, you'll be under the guidance of Shay and Ruth. You might not remember Ruth from the first day, but she was the one that sort of organized you when you first came in. And so they will bring you together with the alternates for lunch, but then once lunch is done, you'll break again and the alternates are kept in a separate location. Okay? And the court will just check back with you. From now on, you can't go anywhere or do anything without receiving permission of the court, and you'll be escorted everywhere you go. Okay? So Shay will just check in with you. If you have a question or an issue or want to take a break, just ring the bell, and we'll make sure we have people there to escort you. Okay? You go nowhere by yourself anymore. Everyone understand that? Okay, you are officially sequestered. And then all further proceedings are going to be taking place back in my courtroom, okay? And I've already indicated if there is a verdict, if there is a verdict today, even if it's tonight, the court's going to grant a certain period of time after I'm indicated what that is, just so that all the family members of the parties can be present. So it won't be an immediate. It may take 30 to 45 minutes before we actually take the verdict, just so everyone's aware in advance. Okay? All right. Thank you, and you're now going to leave with Shay, and let's let the jury leave first, ladies and gentlemen. All rise. I just want to speak a little bit to the gallery. I want to thank you all for your civil and decent behavior. I know how difficult this case has been for everyone, and the court understands how important it is for everyone to be a part of this case if there is a verdict, and that you may want to be a part of that. So I'm just going to ask you to maybe, if you're with a group, if you're in contact with the prosecutors, that's fine. Just make sure they have your contact information. If you're in contact with the defense lawyers, that's fine. Just make sure they have your information. And you need to be within about 20 to 30 minutes of the courthouse, or you will miss the verdict. So please don't drive an hour home and think that we will wait for you, because we won't be able to do that. But I give about a 20 to 30 minute window to allow everyone to arrive if there is a verdict, okay? So just keep in mind with the parties, if there's someone here that is with the media or is not with either of the parties and you're going to want to be notified about the verdict, then please go over to my chambers and give that information to Shay, the bailiff. Give a number where you can be reached, all right? And then they're going to move the line, right?
Yeah.
Right. Okay, thank you.
I wasn't here the first day. Yeah, actually, no. It's in the last time. No.
Yeah, my court is different. So it's closed right now.
They made it first for people up there.
All right, well, I'll be over there. Hey, Jay, are you hiding today? Oh, see ya.
What's up, J-Bo? Get this, last night, green cockroach, yellow. And they went to one cockroach.